And let me share. There we go. Okay, so we're good. So, Baruch atah Adonai Eloheinu melech haolam shekidshanu b'mitzvotav v'tzivanu la'asok b'divrei Torah. So we left off last time, ready to start a new Mishnah on page 129 of the Koran PDF, or we're on page, where is the page number here? 23A of Bava Batra. Okay, one must distance a dovecote 50 cubits from the city to prevent doves from eating seeds in town. There's a note here. I just want to look at 50 cubits from the city. Okay, that's the halacha. Just a second. Here it is. 50 cubits from the city. Rashi explains that the doves eat garden seeds. Alternatively, the birds devour the grains and seeds that are laid out to dry on the town's rooftops. Okay, so the medieval rabbis are trying to help us understand what the issue is if doves are closer to the city. What kind of personal property might doves be eating? Okay, and a person should not establish Bess, yes?
The first thing that came to my mind, and just me maybe, was that there would be too much pooping in the area.
Oh, I don't think people mind the pooping. Just a second, I'm closing my door.
Oh, okay.
Imagine the filth that, even 100 years ago, streets were dirt. There was filth in the street, all kinds of filth, human waste, horse waste, donkey waste, all of that. So I think people are used to that. And also, all that waste can be put to good use as fertilizer, not the human waste, but the other. And I don't think that that's the issue. Because like I said, if a dove poops on your property, people would see that as a positive. Okay, and a person should not establish a dovecote within his own property unless he has 50 cubits in each direction between the dovecote and the edge of his property. Okay, so so here's another limitation of a business that you can establish on your property as long as it is far enough away from other people's property. So 50 cubits, 50 times a foot and a half is what? 75 feet. So 75 feet is divided by 3. How many yards is that? 25 yards, which isn't very far, actually. 25 yards. I'm just picturing a football field. 25 yards. That's it's really not that far at all. And birds certainly fly longer distances than that. But maybe doves in a dovecote are trained to stay near the dovecote. Rabbi Yehuda says that one must have surrounding the dovecote the area required for sowing 4 core of seed on each side, which generally extends as far as a dove flies in a single flight. So there's a background on area required for sowing 4 core of seed. A bait core is the area of land in which one would sow 1 core or 30 seah of grain. The amount of land required for 1 seah is 50 cubits by 50 cubits. 2,500 square cubits. A bait core is therefore an area of 75,000 square cubits, which is approximately 18,750 square meters. That means nothing to me. I can't picture that. But it's the distance a dove flies in a single flight, so that's the importance there. So the anonymous statement of the Mishnah is 50 cubits, a distance. Rabbi Yehuda says the distance that a dove flies in a single flight, which I think is a greater distance. And if one bought the dovecote with the land, he has the acquired privilege of its use, even if it has surrounding it only the area required for sowing a quarter kav of seed, or a beit rova around it, and he need not remove it from there. Okay, so if the dovecote was already there and the amount of space between the dovecote and the neighbor's property is less than what we're saying, it's okay because the dovecote was there already. Okay, so that's the Mishnah. Gemara on this. The Gemara asks, must one distance a dovecote only 50 cubits from the city and no more? Is that as far as one can expect a dove to fly? And the Gemara raises a contradiction from a Mishnah, which is in Bava Kama, so we're in Bava Batra, so it's like the same unit, but it's many chapters before. One may spread out traps for doves only if this was performed at a distance of at least 30 ris, or 4 mil, which is 8,000 cubits, from any settled area, to avoid catching birds that belong to another. Apparently, doves fly a distance of 30 ris, whereas the Mishnah here states 50 cubits. Right? So, is there a difference now between catching doves and your own doves maybe harming other people's property? Right? So, what is the distance that we think doves fly that then you don't have a grievance against the dove owner if the dove owner, if the dove damages property, or maybe also grievance that the dove owner might have to someone who trapped his dove because it was so far away. Okay, so you have two different kinds of cases. You have a case of somebody who wants to catch doves. How far does he have to be out in the wilderness for it to be assumed that these are wild doves and they don't belong to anybody? And how far does the dove owner have to keep his doves away from property so that the dove shouldn't be considered having damaged somebody's property? So it is reasonable to compare dove cases, even though they seem to be different kinds of issues. Abaye said, doves do fly great distances, which is why one must avoid catching others' birds by keeping traps 30 ris away from settled areas. But as they eat along their way, their stomachs are filled after a distance of 50 cubits, at which point they will do no more damage to seeds. Okay, so Abaye is suggesting that they are two different cases, because if the issue of 50 cubits from a town is because the dove might eat the seeds in somebody's garden, well, they're going to eat the seeds before they fly 50 cubits, because they're going to look for food almost immediately outside the dovecote. And then once they find it, their stomachs are full and they're not looking for seeds anymore. So says Abaye, the so-called dove expert. The Gemara asks, and do they fly only 30 ris and no more? But isn't it taught in a Baraita? And in a settled area, one may not spread out a trap, even if the area under his control extends as far as 100 mil in each direction. Rav Yosef says that Baraita is referring to a settled area of vineyards, that is, a contiguous region of vineyards and gardens. In that case, the doves pass from place to place, even over a great distance. So it depends what they're flying over and what is planted in the area that they're flying over. Okay? Rava said the Baraita, so Abaye said we're talking about the 50 cubits versus 30 ris or whatever it is about the birds will eat before they even get to 50 cubits. Rava said the Baraita is referring to a settled area of dovecotes, that is, where many dovecotes are distributed. The Gemara asks, and according to Rava, let the Tana derive that one may not establish a new dovecote there due to the other dovecotes themselves, as he will trap doves belonging to others. The Gemara answers, if you wish, say that this is referring to his own dovecotes. And if you wish, say it's referring to the dovecotes of a Gentile whose property one is not obligated to protect from harm. And if you wish, say it is referring to ownerless dovecotes. Right? So there could be some doves that still live in the dovecotes, but there's nobody running that dovecote anymore. Gentile dovecotes, it's interesting because we've seen over the years a blatant disregard for Gentiles in the Talmud, and that we can be surprised about that with modern sensibilities, but we have to understand the time in which the rabbis are living. And if Gentiles don't care about us, that is 1,500 years ago, why should we care about them? So that is a legitimate argument, and you might think that the rabbis would rise above that, and sometimes they do, but it depends on what the laws are. And in this case, maybe the rabbis are suggesting, who cares about Gentile doves? It's only doves.
I have a question.
Yes, Steve.
Why did people have dovecotes?
Oh, that's an interesting question. So I don't know. Let me ask Google.
Is this the time of temple sacrifices?
Yes and no. Just I'm asking the question of Google. People kept dovecotes. This is the AI answer that Google provides. People kept dovecotes to have a reliable source of meat, eggs, and fertilizer. The structures were also a status symbol, as they were often a privilege for the nobility to own. Pigeon droppings were valuable for tanning leather, making gunpowder, and as fertilizer. Okay. Dovecotes were designed with numerous nesting boxes or pigeonholes to house hundreds of breeding pairs of pigeons. The birds would forage for food outside and then return to the dovecote to roost and nest. The structures were often built away from the main house to allow the birds to forage on other people's land. Okay, so that's a quick overview. Okay, now, those of us who may have been to Israel and been on like organized trips where you do participate in an archaeological dig. If you've gone to Beit Guvrin, which are these caves underground south of Jerusalem from the time of the Bar Kokhba revolt, so like 70 years after the destruction of the temple in Jerusalem. There are dovecotes underground. So there are holes in the ground, so from which the doves can fly out of the dovecote that's underground to reach outside. If you just Google dovecotes, you'll see what they look like. They're these big structures that are outside. Okay, so Rabbi Yehuda says that one must have surrounding the dovecote the area required for sowing 4 core of seed on each side, which is as far as a dove flies in a single flight, right? This is from the Mishnah with a different of opinion from the anonymous source, which says 50 cubits. So Rabbi Yehuda says area required for sowing 4 core of seed. And if one bought the dovecote with the land, he has the acquired privilege of its use. So Rav Papa said, and some say it was Rav Zevid, that is to say that a court issues a claim on behalf of a buyer and issues a claim on behalf of an heir. This is referring to the halacha of taking possession. If one has been physically in possession of an item for a period of time, generally 3 years, this serves as proof that he is in fact the legal owner. This possession must be accompanied by a claim of how one acquired the item. He cannot simply state that no one protested his possessing the item for 3 years. Rav Papa is saying that the court will lodge a claim on behalf of a buyer or heir that they acquired the item from someone who was the owner, just as here the court assumes that the previous owner of the dovecote came to an agreement with his neighbors that he may use it. Okay, so in other words, we're understanding that there's some kind of official document which gives the new owner of the land the right to use that dovecote. The Gemara asks, yes, Bess?
Are doves like homing pigeons? They come back to the.
I think they are trained that way, yes.
So do these people train their doves to come back?
I don't know. I really don't know. You can Google that, but I'm sure. I don't know. I just think that doves, pigeons, they just are used to what their home is. It's like eagles or any migratory birds. No, not any. Many migratory birds come back to the nest that they had built the year before. And there's just something in their brain that enables them to remember this is their nest. So I think that that's what pigeons and doves do. Once they know that this is their nest, then they know to come back to it and not go to somebody else's. And I don't know, dovecotes look the same, but I imagine there's a distinct smell or some other kind of way for doves to know which is their hole and what's not their hole. But I don't know more specifically than that. So the Gemara asks, why is it necessary for Rav Papa to state this halacha? We already learned this with regard to an heir on page 41a, coming up in 20 pages. In the case of land that comes as an inheritance, one is not required to make a claim as to how the land came into his benefactor's possession when one's ownership of the land is challenged. The Gemara answers, it was necessary for him to state this halacha with regard to a buyer. So there's a difference between an heir gaining property that way versus someone buying property. Different level of proof or paperwork. The Gemara asks, with regard to a buyer as well, we learned this in a Mishnah on page 60a. If one bought a courtyard, in which there are projections and balconies extending into the public domain, this courtyard retains its presumptive status. That is, the owner has the acquired privilege of their use, and the court does not demand their removal, right? Once something has been built on somebody's property, the new owner of the property doesn't have to remove it. The Gemara answers it was necessary for the Tana of the Mishnah to state this halacha in both cases, as if he had taught us this only there. In that Mishnah, one might have said that it applies specifically with regard to a protrusion or a balcony that extends into the public domain, as one can say that perhaps it is a case where the seller had drawn back into his town, into his own land, before adding the projections and balconies, and they in fact do not extend into the public thoroughfare. Alternatively, perhaps the public waived their right to him and allowed him to place them over the common area, as otherwise they would have protested. But here, where he causes damage to private individuals, one might have thought that the buyer does not have a privilege of use, and therefore the Mishnah teaches us otherwise. Right? There's no potential damage to balconies that were built, but there is potential damage to a dovecote that's within 50 cubits or the area of sewing a bait core to the next person's property. So, and if he had taught this only in the Mishnah here, one might say that since the party potentially suffering damage is an individual, the owner of the dovecote appeased his neighbor by paying him to permit him to construct it. Alternatively, the neighbor might have waived his right to him. But in a case where damage is caused to the public, one might argue, whom did he appease and who yielded to him? Consequently, one might say that the purchaser does not retain the privilege of use. Therefore, it is necessary for the Tana to state the halacha in this case as well. So there could be other issues involved, but that's why we needed this specific case to ensure that people understand that about the dovecote, this is the law. Okay, the Mishnah teaches that if one bought the dovecote with the land, he has the acquired privilege of use. The Gemara asks, but doesn't Rav Nachman say that Rabba Bar Avu says there is no acquired privilege of use for cases of damage? Why should he retain his acquired privilege of use when his doves cause damage? Rav Mari said, Rav Nachman's statement is referring specifically to smoke, which causes serious damage, and that is why it overrides an acquired privilege. Rav Zevid says it's referring to a bathroom whose odor is particularly strong. So not dovecotes, but other things like that could, they can cause damage, whether it's smoke or odor.
Talking about kitchen smoke or burning trash or?
Yes. Yeah, I'm sure any kind of smoke. But on to the next Mishnah. With regard to a dove chick that was found within 50 cubits of a dovecote, it belongs to the owner of the dovecote. If it was found beyond 50 cubits from a dovecote, it belongs to its finder. In a case where it was found between two dovecotes, if it was close to this one, it belongs to the owner of this dovecote. If it was close to that one, it belongs to the owner of that dovecote. If it was half and half, that is equidistant from the two dovecotes, the two owners divide the value of the chick. Okay, so if we care about what nipul, the word for a chick is, you can on your own look at the language, but okay, so finding a dove. Rav Chanina says, when resolving an uncertainty with regard to the halachic status of an item, for example, a found item, if the status of the majority of like items indicates that it has one status but the item in question is proximate to a source that indicates otherwise, one follows the majority. So there's a note there, and let's figure this out, because that's legalese. Okay, some early commentators maintain that Rabbi Hanina is not teaching that one follows a majority rather than proximity, as this is stated later with regard to the 9 stores, which we'll get to. Rather, the novelty of his statement is that even in the presence of an obviously close determinant, one follows the majority, although it's ostensibly logical to rule based on proximity. So, when resolving an uncertainty with regard to the halachic status of an item, if the status of the majority of like items indicates that it has one status, but the item in question is proximate to a source that indicates otherwise, one follows the majority. And even though the halacha of majority applies by Torah law, and the halacha of proximity also applies by Torah law, even so, the majority is preferable. Rabbi Zera raises an objection from the Torah's statement with regard to a murder victim where the identity of the murderer is unknown. Yeah, this is in the book of Deuteronomy, where you find a corpse outside of town. Who is responsible for burying the corpse? If we don't know, if there's no other evidence there to determine how the body died, who, if it was murdered, and who the murderer was. In a case of this kind, the court measures the distances between the corpse and the nearby towns in order to determine which town is closest and must consequently perform the rite of the heifer whose neck is broken. Right? Somebody has to take responsibility for this corpse, and the Torah teaches that there's a ceremony that has to take place in order for the closest town to take responsibility and atone for the sin of this person dying. The verse states, yes, Bess?
I forgot. Each town was able to have its own court.
What do you
I thought
mean?
they had traveling judges, the 3 traveling judges, the 1 traveling judge. But here it seems to me that a town has its own court. It measures the distances between the court.
The Torah tells us it's the Kohen who is in charge of this procedure. So I'm not sure how this was done. I don't think we have specific cases to tell us how this Torah law was put into action, but the Torah teaches us that the Kohanim are the ones who are measuring the distance. Okay? The verse states, and it shall be that the city that is nearest to the slain man, the elders of that city shall take a heifer of the herd and shall break the heifer's neck. Okay, so that's what the Torah says. So it's the elders of the town, not the Kohen, and this town is chosen, even though there might be another town that is larger in population than it. According to Rabbi Hanina, in a case of this kind, one should follow the majority. So in other words, the Torah says it's proximity that determines. So in other words, you measure the distance from New York City to Scarsdale, and let's say a body is found between New York City and Scarsdale. Well, New York City is clearly larger in population than Scarsdale, but it's found closer to Scarsdale. Scarsdale has to take charge of the body because the Torah says it's proximity, not majority. Okay, so in other words, like the larger town might have more means available to handle such a case. Okay, the Gemara answers, this verse is referring to a situation where there is no other town that is larger than that one. The Gemara asks, and still, if one follows the majority, why should the court follow the closest city? let us follow the majority of the world, as most people are found elsewhere, right? Most people come from, you would assume, people come from the big place, not from the little place. That's just statistically would be the case. The Gemara answers this is referring to a case where the city sits in isolation between mountains, and therefore it's unlikely that the murderer arrived from elsewhere. The Gemara continues to discuss the issue of majority as opposed to proximity. We learned in the Mishnah, right? So I guess if you're trying to figure out the case where this body may have come from, if it's found between two locations, and like I said, one location is New York City and one location is Scarsdale. So you might assume that the person came from New York City because New York City is just a much bigger place. I'm also assuming there's nothing in between New York City and Scarsdale, which isn't the case, but I'm just using that as an example. So you might argue, one could legitimately argue, if you're going to state that a place has to take responsibility for the corpse, the likelihood that one could argue that the largest population place should take responsibility because it's more likely the person came from the larger place. So the question is, why does proximity matter versus majority in this case? How is that a fair thing? Like if you have a village of 20 and a town of 10,000, why should the village of 20 that just so happens to be closer to this corpse have to come up with this heifer, which it might not be able to afford, and take responsibility for this person, when even most likely everybody in that town probably knows each other and may not have even known that corpse, but the Torah law says that they have to take responsibility for it.
So to this, I was just going to ask this question. You almost answered it.
Yeah.
If this applies even when you know.
Yeah, so right.
As
I said it, Steve, I understood that I was wrong. It's if you don't know the person. But again, what is the likelihood of a person being from a town of 20 people not being known to the other townspeople? And so it doesn't matter. So it doesn't matter if the town. So it is more likely that in a town of 10,000, a person, not everybody in the town knows everybody. So even though he's found closer to the town of 20, and those 20 never saw this person ever in their lives, the Torah says they're still responsible for him or her because they're closer. Okay, so I guess this is the issue that the Gemara is dealing with a little bit here. Why should proximity outweigh majority? So the Gemara continues to discuss the issue of majority as opposed to proximity. We learned in the Mishnah, with regard to a dove chick that was found within 50 cubits of a dovecote, it belongs to the owner of the dovecote. And as the Mishnah does not make a distinction between different cases, it indicates that this is the halacha, even though there is another dovecote that is larger than the proximate one in terms of number of birds. This shows that closeness, not majority, is the determining factor. The Gemara answers, this is referring to a case where there is no other dovecote in the area. So now then, in other words, the Mishnah might be different if it's talking about several dovecotes in the area. The dove is within 50 cubits of several dovecotes. How do you then figure out which dovecote the dove belongs to? The Gemara asks, if so, say the latter clause of the Mishnah, if it was found beyond 50 cubits from a dovecote, it belongs to its finder. And if there's no other dovecote in the area, it certainly fell from that dovecote. How then can it be given to the finder? The Gemara answers with, what are we dealing here? We're dealing with a chick that hops from place to place, but does not yet fly. As Rav Ukva Bar Chama says, with regard to any creature that hops, it does not hop more than 50 cubits. Consequently, any bird found within 50 cubits of a dovecote is assumed to have come from there. If it's farther away than that, it likely came from elsewhere or was dropped by travelers. Okay. Rabbi Yirmiyah raises a dilemma. If one leg of the chick was within 50 cubits of the dovecote, and one leg was beyond 50 cubits, what's the halacha? Like he's on the chick is on the 50 cubit line. The Gemara comments, and it was for his question about this far-fetched scenario that they removed Rabbi Yirmiyah from the study hall, as he was apparently wasting the sage's time. Oh, that's great. This is what we call a klutz kashya, kashya being Yiddish for a question. And this is like, okay, there are questions, there are legitimate questions, there are interesting theoretical questions, there could be questions that bend the logic, and then there are questions like this. What if we find the chick on the 50 cubit line? So it gets to a point then, okay, that questions are good, and you want to encourage people to ask questions, but when you get to a question like this, get out of the study hall. So that's funny. The Gemara further suggests, come and hear the Mishnah. In a case where it was found between two dovecotes, if it was close to this one, it belongs to the owner of this dovecote. If it was close to that one, it belongs to the owner of that dovecote. The Gemara comments, and this is the halacha, even though one of them is greater in number of birds than the other one. Apparently, one rules based on proximity, not majority. The Gemara explains, with what are we dealing here? We're dealing with a situation where the two dovecotes are equal in size. The Gemara asks, but even so, why should one follow the closer dovecote? Let's follow the majority of the world, as there are many other dovecotes besides these, and the number of doves they contain is greater. The Gemara responds with what are we dealing with here? We're dealing with a path that passes between vineyards, and these two dovecotes are situated there. As if it is so that you claim the chick came from anywhere else in the world, since it only hops, it could not have come there. The reason is that any bird that hops and turns and sees its nest will continue to hop. But if it does not see its nest because it has gone too far, it will not hop farther. Consequently, this found chick that hops must have come from one of these two dovecotes. So I don't know if the rabbis are right about that. Do chicks know to stay close to home? I really don't know about that. Abaye said, we learn in a Mishnah as well that one follows the majority rather than proximity. With regard to blood that is found in the corridor, that is the cervical canal, and it is uncertain whether or not it is menstrual blood, it is ritually impure as menstrual blood, as there is a presumption that it came from the uterus, which is the source of menstrual blood. And this is the halacha, even though there is an upper chamber which empties into the canal, which is closer. Okay, so I can't wait that when the 7.5 years of Daf Yomi cycle ends with the tractate Nida. And I can't wait to get to, and it happens to be like 100 pages long, dealing with this kind of issue of menstrual blood, and male rabbis, dealing with an issue that is a feminine issue. So it'll be very interesting to read in that section, especially there understanding or lack thereof of anatomy. But here we're going with blood that is found to determine whether a woman is impure or not. Where is the blood found? And what assumptions do we make? You could assume that a blood could come from a different source within the woman's body, and that might still keep her pure. But we're saying that that the presumption here is the majority and not the proximity. That most often blood found in a woman is going to be menstrual blood. So sometimes you go with the majority, the most likely case, or you go with proximity, the closest source.
I don't know if you want to go into this, but who's checking out her cervical canal?
Not sure. We'll have to. It's unclear whether rabbis trust women to with their evidence when they come to a rabbi to question with a question as to whether a particular blood. So rabbis were proficient in knowing the difference between different colors of blood or very different hues of blood to determine to understand the source of that blood. But I don't know if the rabbi is physically checking or allowing the woman to physically check. Don't know. And I don't know if the rabbi's in the room with the woman while she's checking or not. I really don't know. We'll have to see when we get there. Rava said to Abaye in response to this claim, "You state a proof from a case where the factors of majority and frequency are both present. When there is majority and frequency, there is no one who says that one ignores the majority and follows proximity. Here, not only is the blood from the uterus greater in quantity, it also passes through the canal more frequently, as blood generally does not come from the upper chamber." I don't know what they're talking about with the upper chamber, but it doesn't matter. It just comes from that most likely blood in that location is coming from the uterus and not someplace else. Rava cites a proof for his statement, as Rabbi Chia teaches. Blood that is found in the corridor is considered definite menstrual blood, and therefore if she engages in sexual intercourse, both she and her partner would be liable as a result of it to receive karet for entering the temple intentionally when ritually impure, or to bring an offering for entering unwittingly. And one burns truma due to it if the woman touches such produce. Evidently, the status of this blood is not considered uncertain. So no question at all. It makes the woman impure, and if the woman and her husband disregard her impurity, they're both liable to this very severe punishment. And Rava says, learn from that which Rabbi Chia said, 3 conclusions. Learn from his statement that when the relevant factors are majority and proximity, follow the majority. And learn from this statement that the halacha that one follows the majority applies by Torah law, as truma is burned in this case on account of the blood, and she is liable to receive karet if she enters the temple in this state. And learn from his statement that there is a source for that which Rabbi Zera said. The statement of Rabbi Zera was issued in reference to a case discussed in Tractate Ketubot. If there are 10 stores in a city, 9 of which sell kosher meat, and 1 of which sells non-kosher meat, and one found meat outside the stores, and he does not know from which store it came, one follows the majority. The Gemara there suggests that perhaps one follows the majority only in a case where the gates of the city are unlocked, when the meat could have come to the city from the majority of kosher meat outside in a circumstance where the majority of the meat sold in the surrounding area was kosher. In this case, there are 2 majorities, the majority of kosher meat stores inside the city and the majority from outside. The Gemara there explains that Rabbi Zera says that even if the city gates are locked, one follows the majority and the meat is kosher, and there's no need for a double majority. The Gemara elaborates. The two cases are analogous, as the woman here is considered like the locked gates of the city. That is, there is only a single majority, and even so, we follow the majority. The Gemara asks, but Rava is the one who says, with regard to the case of the blood, that when there is majority and frequency, there is no one who says that one ignores the majority and follows the proximity. In other words, Rava rejected this case as proof of the principle that one follows the majority even when it's not frequent. Here, by contrast, Rava claims that one can learn from the ruling of Rabbi Chia that one follows the majority by Torah law. The Gemara answers, Rava retracted that claim in favor of the opinion that one follows the majority in all cases. Okay, it's 10:17. We come to a red S, and we're going to stop here for today. And because I got things to do to get ready for other things in Hebrew school. So we will meet again next Sunday, and then the following Sunday we are off. So take care, everybody. Have a good week. And,
Thank you. Be well.
See you next Sunday. Thanks. You too.